22 CR 49.
On the record, Parks.
Case number 22 CR 49, State of Ohio versus Thomas J. Parker. The state is prosecutor King Kern for the defense attorney Daniel Witt. This is a matter set for upon pre-trial. Parks has been in the Huntington County Jail, but the court yesterday, DRC, without permission of the court, removed him from jail and took him to prison and has been placed at the Range Correctional facility or whatever the term of the DRC is. And so the court is going to order the case be on the inactive docket. And due to his unavailability, because it's going to take us 2 to 3 weeks at least to get a pre-trial set up. So we will set up a final pre-trial as soon. And then comment set up Friday after that, a resolution. So the speed trial time is told due to the defense unavailability at this point in the hearing. And so if we can get something set up, we'll pass it out. All right, thank you. All right, we don't say that's early. Annie, can you do these? Yeah. Okay. Are you down to Spark in jail? Pardon me? Okay. Let's see, keep my volume up real quick. I'm already maxed out, so make sure you stay close to the microphone.
Yeah.
All right. Case number 22 CR 22, State of Ohio versus Devin Clark. Clark is appearing by video from the Justice Center. His attorney is Captain Hammer during Zoom, and representative states and the prosecutor is also going to do. The defendant is charged with several co-defendants. He's only charged, I believe, it counts 17 and 18, and that's it, I believe, right?
That's correct.
Yeah, okay. All right. I believe this is the final pre-trial, is it not?
It is.
Okay, and what's the status of the case, counsel?
Mrs. Collins and I have been communicating about it. I think basically have a resolution or very close there too. As you're aware, Mr. Schwartz was in the Fairmont County Jail for a while, so he was unavailable to me. But I don't think we have a trial date set at this point. His trial date was vacated due to his arrest in Fairmont County.
He has a trial set for September the 19th.
Yeah, I was going to say, I have here notes from the 19th of July that we set today for the final pre-trial, and September 19th is the trial date. So,
And that's I wasn't here on the 19th of July, so you may not have gotten confession. I think.
Yeah, I think that was just a bond review. Yeah.
Yeah.
Okay.
I think we are close. Oh yeah, and I'm not available the 19th day. That's my regular day in Fayette County. But I don't think it matters because I think we're close to a resolution.
Okay.
I anticipate that we'll have something for the court within a week.
All right. Well, we'll just go ahead and I won't say anything further until I hear from the court or hear from the counsel.
Okay.
All right. Thank you.
Thank you.
Is that next?
Heather Trivet.
Heather Trivet? Yeah, Mr. Wagner's client?
Yes, Your Honor.
Wagner, before we get started, just so you know, I just signed an order denying your motion for ordering retesting in the Hershey case by PCI.
Yes, sir.
All right, case number 22 CR 42, State of Ohio versus Heather Trivet, President for This hearing being conducted by Zoom. You are Heather Trevette, currently in jail.
Yes, sir.
All right, Mr. Wagner is, our attorney, he's appearing, by Zoom, as well as the prosecuting attorney, who's on behalf of the state. Mr. Wagner, you and your client both agree this matter to be conducted by Zoom rather than an in-person hearing.
We are, Your Honor.
You all right with that, Mr. Trevette?
Yes, sir.
All right, Mr. Trevette is charged with, aggravated trafficking of meth and aggravated possession of meth, both, for three felonies, Friday of, August 22nd. I've been presented with a plea of guilty form, Ms. Trevette, which indicated that you're going to, withdraw or not guilty, plead guilty to count, one. Now, this is a 3-page, document that, prosecutor's office prepares, and, on page 3, there's signature lines. First, I'll show you the front page. It shows see your name and plea guilty, case number, and everything there.
Yes, sir.
All right. And then on page 3 of this document, there are signature lines, and about not quite halfway down, there's a sentence that reads, "I enter this plea voluntarily." Immediately below there, there's a line which has signature pen print below, which appears to me to be Heather Trevette. Is that your signature there?
Yes, Your Honor.
When did you sign this document, Mr. Trevette?
I signed it yesterday.
All right, did Mr. Wagner go over with you before you signed it?
Yes, sir.
And you understood when you signed it, this agreement to plead guilty, which means it won't be a trial. The next step in your case will be a sentencing hearing.
Yes, sir.
You feel you had enough time to fully consider this matter before making this decision?
Yes.
Aggravated trafficking of methamphetamine, violation section 29.5.03A1, hired by the code 33 felony, for the state to understand maximum penalty for that would be 36, could be 36 months in prison, minimum of 9, different levels in between those two ranges. Fine of $10,000 possible with a mandatory fine of $5,000, license penalty 6 months, 5 years. And there is a presumption that prison term should be imposed. You understand that?
Yes, sir.
Are you facing any penalty charges in any other jurisdiction?
No, sir.
Are you currently on probation, being controlled, parole, or post-release control for a felony?
No.
Now, under the law, if you are convicted of this offense and if you are sentenced to prison, the law provides that the adult parole authority has the option, they have to choose to exercise it, to put you in what's called post-release control supervision for up to 2 years, which means you'll be supervised on terms they set by a parole officer. If during that period of time they determine that you have failed to comply, then they can return you to prison, making you serve an additional period of up to 9 months for any single violation. Although there is a cap of half, whatever prison term is awarded for all violations. However, if you committed a felony while under post-release control, this is wherever sentence the judge in that new case imposed by that judge is also authorized to sentence you for committing that offense while under post-release control in this case. Additional period of 1 year. Whatever time's left on the post-release control period, whichever greater, that occurs, and has to be served the second sentence in the new case. You understand that?
Yes, sir.
Under the law, I'm not prohibited from imposing community control. There's a presumption I should impose prison, but it's not mandatory. So, if I decided that you should be given a community control set of prison sentence, that means you put under supervision of a probation officer for a period of up to 5 years in the term set by the court. If during the period of time you were being supervised, the probation department does what you were not complying, they would file a written notice that the court, it would be given a copy, there would be a hearing, you'd have to have an attorney that hearing. The outcome of that hearing was that you failed to comply, and at that time the court would look at your control and sentence you to 36 months incarceration and fine and $1,000. You understand that?
Yes, sir.
All right, now the charge alleges that on or about April 26, 2021, Manning County, Ohio, that Jonathan Cumberland you did knowingly sell or offer methamphetamine, getting 2 controlled substances amounting to exceeding bulk amount less than 5 bulk amount, violation section 29.5.03A1 of the Ohio Code. So that's the charge. Aggravated trafficking of methamphetamine, third-degree felony. Now, do you understand what it is you're charged with, and then county indictment, what the state said you did, when, where, and how they alleged did it?
Yes, sir.
You discuss the nature of the charge, evidence of the case, possible legal issues of the case, possible defense by preparation trial, as well as the possible outcome of the trial with your attorney.
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any type of drugs or alcohol at this time?
No, sir.
Have any threats made that you plead guilty here today?
No, sir.
Now, on page 2, there are about 4.5 lines printed in bold. And underlined, which read as follows: Convention on legal count 1, state discount 2, state convention on direct generation. Defendant agrees to pay back $5 million tax for the amount of $220 from several. John and Cumberland, defendant agrees to cooperate fully against both defendants and cooperate fully with tax. That's your understanding of the agreement?
Yes, sir.
Does anyone want to say anything on that recommendation? I could impose any sentence up to 36 months as permitted by law, fine $10,000, and also suspend your license for 6 months to 5 years. That's what I think is the appropriate sentence. Do you understand that?
Yes, sir.
Right now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
And you have certain rights to understand the court, I accept guilty plea from you. First, you have a right to have counsel. In this case, Wagner appointed representation. I wasn't sent to work the case out, but by any defense that might be available to you in the law, which we should apply. So, if you decide that you do not want to do this, that you want to defend against the charge, we will continue to be represented by Mr. Wagner. Do that including a trial message form. You understand that?
Yes, sir.
Under the Constitution, you have a right to have a jury trial in this matter. There's 12 people to be selected from a group of citizens that live in this county, some for jury duty after trial day. After they're selected, the evidence will be presented, the jury will be instructed on the law, and that jury have to decide on a unanimous verdict. You know, 12 of them have to agree on the verdict before you can be found guilty. Now, if you did not want to have a jury trial, if you did not want to plead guilty, you can waive the right, which means you give up the right to have a jury trial. In that case, you have what's called a court bench trial, meaning instead of jury hearing evidence, it will be the judge who hears the evidence by the law, decide whether or not to state jury for guilty, prove boundaries for that. Do you understand that?
Yes, sir.
And under the Constitution, you have a right to confront witnesses against you and cross-examine the jury. What that means is that the witnesses against you have to come in court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that would be to bring evidence to help your side of the case. You understand that?
Yes, sir.
Right, under the Constitution, you have a right to use the power of this court to help, of course, witnesses come to court and testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, it's your request for issues of court order, that's a subpoena, and that forces those people to come to court and be available to testify if they want to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court and testify against you. You understand that?
Yes, sir.
Now, the Constitution does prevent you to have privilege to self-incrimination, which means you're not in court to give evidence against yourself at any time to the trial. Don't ever make a testify. The prosecutor can, the judge can, it's your decision, and if you decide not to testify, the fact that you did not testify, not used against you in any way by any person at any time in the proceedings. In fact, no one's even allowed to talk about it during the case, except in one situation. There's a jury trial when you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, you're presumed innocent of the charge shall prove guilty by the state of Ohio on every essential element of the offense charge. What that means is the burden of proof is on you to try to prove you're not guilty simply because you're confused. In fact, under the law, you don't have to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt, prove beyond reasonable doubt, which is the highest burden of proof established under the law. You understand that?
Yes, sir.
Right now, originally, you're pleaded not guilty. That leads to an allegation in the indictment that I committed a crime and exercise or revoke all the rights that I just described. Now, if you change your plea today from not guilty to guilty, that is down to the not guilty. That's the allegation in the indictment, that's a third crime, you committed that crime. That plea wages up all the rights that I just described to you today, except the right to have an attorney. You always have the right to have an attorney no matter what your plea is, with that exception. If you plead guilty, wages up the right to a jury or court trial, wages up the right to confront witnesses against you and cross-examine your attorney. Wages up the right to use the part of the court, help of course witnesses being court and testify for you, just like the state. Wages up the privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty, wage your presumption of innocence, because if you say you're guilty, the state doesn't have proof of it. Subject you being sentenced immediately by the court, and finally, wages up any right to file appeal you think you may have at this point in the case. Now, if I should sentence you to the maximum sentence, none of the certain limited circumstances you can file, if you have to file for 30 days, your sentence to enter be filed. You understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Do you have any questions about the charge of multiple penalties?
No, sir.
You understand it?
Yes, sir.
Any questions about the plea agreement?
No, sir.
You understand it?
Yes.
Any questions about the constitutional rights of the claim?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you have that plea here today?
No, sir.
You understand that?
Yes, sir.
And, yeah, any questions that you'd like to ask Mr. White about before we go any further? I forgot to say at the beginning, and I can't with the two in a breakout when we need to talk to him.
No, sir.
All right, have any questions about anything I explained?
No, sir.
And is it your decision to withdraw your not guilty plea, guilty to the charge, count one, so the terms of the plea agreement we just got with?
Yes, sir.
All right, then as to the charge, count one, which alleges that, on or about, April 26, 2021, I had Ohio, Jonathan, and Cumberland used his own several office of methamphetamine, given to control substance not equal to a city bulk amount less than 5 times bulk amount, violation section 2925, 00381, Idaho Code. The charge of aggravated trafficking methamphetamine, third degree felony, carrying possible prison term from 9 to 36 months, by the law. A fine of $10,000 and for a fine of $5,000, cost twice suspension. 6 months to 5 years. How do you believe?
Guilty.
For finding this state of court, then provide all the constitutional rights made by the alcohol fair with the same section 11, please section 4 5, as found guilty of count 1, count 2 dismissed. The court finds that the defendant has previously been convicted of a felony. There is a recommendation of probation, sentencing in the court case, for present court, so court proceeds sentencing. Take the state.
Your Honor, we would ask the court to follow the joint recommendation of the parties. We would note that Ms. Turbitt does have a prior felony conviction out of this court. Memory serves me correct that she was not extremely successful on community control, though I think eventually did complete it. We would note that the restitution in this case is $220 to the federal with the co-defendant. And finally, we would note our appreciation of Ms. Turbitt taking responsibility for her actions in a timely fashion. She was just arraigned on this case at the end of June, and is already prepared to enter a plea of guilty and be sentenced. So we do appreciate that. Thank you.
Right.
I would echo Ms. Collins' statement, Your Honor. We are in agreement. We did take some time to get the negotiations resolved here. Spent several days with Heather after reviewing the evidence. Went over actually there was only audio, there was no video in this case. We weighed our odds, and again, this is a non-voluntary agreement. We asked the court to follow the recommendation, Your Honor.
All right, Mr. Bennett, anything you want to say?
No, Your Honor, thank you.
All right, so we're going to the court should be in our hereby sentence to the state former court of women at American, Ohio, for a period of 12 months. For the sheriff, we have 43 days of credit. The rest of June 22nd, that right?
Yes.
Okay. Now, we're also ordered to pay court costs for judgment and execution order. Federally, that is reflected by the clerk of the judgment, who led the bank calculator for us. We have that reflected in the clerk. Once you get out of prison, a lot of prison work. A lot of you do service in this county, you can get credit for your work in, I said before, you start working, you should. Cool. Now, on completion of your prison sentence is possible to all full court issues, which are close to parole for a period of up to 2 years. If they do, supervise the term they set, and during that period of time, they determine if they have to apply. They are treated in prison. They can serve an additional period of up to half the prison term for one or more violations. However, if you are convicted of felony law, then an additional sentence judge in that new case, that judge can also sentence you for putting up as one of those control case for additional period of 1 year. However, on that period of control judge greater than occurs, that's considered consecutive sentence in the case. You're also required to pay restitution, $220 on a several Jonathan and Cumberland to the task force, and you pay with this escrow account. You can pay any service fees that are required. Anything further, counsel?
May I?
Yes, sir.
Man back to custody and stuff for that day.
Thank you, Your Honor.
Nominations.
Kyle May.
Kyle May. Alright, are you calling me here from jail?
Yes, Your Honor.
Alright,
I'm
please.
going to break out room in for a minute.
Alright. Well, you've had a little trouble with this, and maybe you'll have to leave the meeting and come back in. And so if that happens, just go back in, and I'll probably wait and call another case while you're doing that.
You can't.
Hello?
Hold on there, I have to break that. You're gonna see a button will come up there in a minute that says, join breakout, and I'm clicking on, the jail and Mr. Armstrong. When that button comes up, you hit that, and then when you're done, if it's working correctly, it should be a button that says leave breakout room, but if it's not, it says leave meeting, then, you have to hit that, and then, we've been having an issue with Zoom, so you'll have to log back in if that happens. All right, this next case up.
Jail still. We have Miss Whip, I think it's,
Oh, okay, but you've got a line for a minute.
Bolton House was here, Coyle's not here yet.
Okay, grab hold now for a minute.
My out of custody person's not here.
Who's that?
Sierra Wilson.
Wilson's not up till 2.
You know. All right, this is case number.
1 second.
Case number 220150, State of Ohio versus Barley Old House. President of the state, prosecutor King, President of the defendant, Attorney Daniel Witt. You are Robert A. Bolthouse. Bolthouse is charged along with three other co-defendants in a multi-count indictment. He is charged, looks like, in counts 9 through 14. This is a pre-trial, I believe, and final pre-trial is here it is set for the 7th of September. Trial date is set for the 19th. The state provided discovery and the particulars. I don't think you provided your jet access.
No, Your Honor.
This will be by pre-trial. State pre-trial motion.
No, none at this time.
Well, there are others, but as well. The officer provided.
There has.
They're not aware.
Yes.
Are there any other matters you can discuss in this case at this time?
There you are.
No, Your Honor.
All right, I'll see you back in 7 minutes. Thank you. Who else do you have?
Kimber Coyle.
Well,
Yes, sir.
she's there as well. Case number 220153. They will have his name in Boyle, but it states that. Okay. You are member in Boyle.
Yes, sir.
Boyle died along with 3 co-defendants, 16 count total, so she died in counts 1 and 2, and 5 and 6. This is the first pre-trial. The final pre-trial is September 7th, and the trial date is September 26th. I see that the state has provided discovery, and the neighbors have you provided discovery yet.
Not yet, Your Honor.
We do by the final pre-trial, and you anticipate pre-trial motions.
No, none at this time.
And is there a written plea offer provided yet?
There is.
You're not worried.
She will be when we finish her.
All right, well, any other matters to discuss at this time then?
No, Your Honor.
All right, September 7th, see you back in 12 minutes.
Thank you.
All right, Mr. Armstrong, will you get back in? All right. Looks like we still have that same problem.
He has an in-person one here too later, or at 1, and then a jail one at 1.
All right, back on record on this for May.
May, just a moment.
22-077.
Back on with May.
All right, We are back on record then. Mr. Armstrong, you can find both agreeable to this matter being held by Zoom.
Yes, Your Honor.
All right. Defendant is charged with aggravated possession of fentanyl-related compound, aggravated possession of amphetamine. This is the first pre-trial, final pre-trial, September 7th, trial date is September 26th. I believe the state provided no particular discovery. Have you filed your discovery yet, Mr. Armstrong?
I don't see a copy of my file, Your Honor.
I don't have it. We do by final pre-trial. You anticipate pre-trial motions?
Only this, Your Honor, my client has been accepted the offer by the state. If you got any time tomorrow afternoon, possibly.
I don't. I'm going to be out for the next 30 days. So, it has to be Tuesday.
Okay. We'll get a marshal, Your Honor.
Okay. All right. Anything else to discuss?
No, Your Honor.
All right, and we'll see you whatever can be arranged. Okay.
Thank you.
All right, Sean Gillespie is next in the deal. In case number 220145, State of Ohio versus Sean Michael Gillespie. Are you Sean Michael Gillespie?
Yes, I am, Your Honor.
Gillespie returned from jail by Zoom. His attorney is Willie Warner, travel there by Zoom. His office is attorney at the prosecutor's office, the prosecutor in office. Then charged with one assault police officer, grand theft of motor vehicle, aggravated possession of amphetamine. This is not a pre-trial. Trial is set for August 25th. Now, discovery complete from both sides.
It is from the state, Your Honor.
Mr. Wagner and Mr. Armstrong, if you thought here, love to see it.
I don't see it in my file, Your Honor, so it's probably that long.
All right. I need to get that filed then. Do you anticipate any pre-trial or the happening of pre-trial motion file, right?
No,
He
no.
filed his response to discovery on July the 25th, Your Honor.
Oh, okay. All right, good. So discovery is complete. All right. So, where do we stand on the case? Is going to go to trial or is there still ongoing negotiation with that?
Well, Your Honor, I spoke to the prosecutor, my client, he's, I believe the prosecutor really would like to take a polygraph in this matter. The issue we've got, when I talked to him about, he was not inclined to sign a time waiver. This was just, this is scheduled for trial on August 25, the day after her service. So, the likelihood of me being prepared for trial on that day are slim enough. So, I don't know what the time factor is for the court. And I know that they talked to Mr. Bolger about retaining him. I don't know if they've done that yet or not. But it takes Ms. Conwell to take a couple weeks to arrange a polygraph at this point.
Typically.
See.
2 to 4. Typically, they get us in within 2 to 4 weeks.
Okay. So obviously, if there's going to be a stipulated polygraph, then it's not going to be done before the trial date. Highly improbable. So, Mr. Gillespie, what do you want to do? You want to stipulate a polygraph and have your case continued, or are you willing to wait for speedy trial time, in which case there won't be a polygraph?
I can't answer that question today. I was told not to sign a time waiver. Can I speak with my attorney privately real fast, sir? I have the witnesses, my state witnesses' phone numbers, the correct ones. Accidentally gave them the wrong ones.
Well, you can take care of that when you meet them in jail. The purpose of talking privately during the hearing is about what's going on in the hearing.
Okay.
You want to talk to them about waiving time? Who told you not to sign a time waiver?
My mother.
Oh, she licensed attorney?
No, she didn't want me to sign anything or do anything because they have an appointment with Mr. James Bolger. So called me today at 4:30 p.m. She still had to text me just a few hours earlier before I could answer this question.
Okay. Well, let me tell you this, if Mr. Bolger takes your case, assuming that you have, your family has money to pay him, I doubt seriously he's gonna be in a position to go to trial on the 25th.
Correct.
So in that case, we're gonna have to continue the case one way or the other. So, when is, I mean, talking to him is one thing, but, are we going, is that going to hire him, or do you know?
I'm at 99.9% sure, yes, sir. She has 4 grand a day. The other 2 grand she's got to get out of her retirement. It's going to take a couple of days before it hits her actual bank account. At 4:30 p.m., my fiance, Brandon Thompson, has an appointment with him. And to see what's going to be said, he might take 4 grand a day and then wait a couple of days for the other 2. But yes, Your Honor, he is probably getting retained.
Well, he'll need to file an entry of appearance immediately then, and ask for a continuance, and then discuss with you and then the state whether or not there's going to be a stipulated polygraph on this. But,
Thank you.
right now, so I'm not going to do anything today, but I see here that you were arrested on the 7th of June, correct?
Yes, Your Honor. I have 58 days today.
Okay, I'm not on after, let's see. 7th was a request for discovery on the 8th of July. And it looks like the state honored their discovery on the 13th. And then, they requested discovery, and, sure, I'm trying to find that, whether you need to be updated. You filed that on July 26th. So, the trial date right now, the deadline would be September 4. And you had, July 8th to July 26th at time was told, so that would be 18 days. So that would extend the trial time to September 22nd if we don't have any further motions or continuances or whatever. So right now, have your attorney, if you get a new attorney, it's going to be file a motion, if not, file appearance, if not, get over Mr. Armstrong, he can discuss it with you, but I'm applying to grant us continuance. And charge that time. Well, number one, if I continue it in September, we're still within your speedy trial time because when the state asks for, you ask for discovery, the state complied, they ask for discovery, you comply, that 18 days doesn't count against your speedy trial time of 90 days, so it extends it to 108 days. And then based upon that, if you want to get a polygraph, that's going to take a couple of weeks to get that arranged. And Mr. Armstrong has indicated he's going to be coming out of a 3-day trial, which I am as well, as prosecutor is, so I think it's probably better for you if we did continue it, if he stays on the case for your own benefit, because he's going to need to have a little time to get through that case and be prepared for your case. So, anyway, I'll just leave it the way it is and wait to hear. All right.
Thank you, Your Honor.
All right. Thank you. I will make those set status conference. Tell you what, let's go ahead and set status conference. Let's be safe on this case. It's on August, what's next Friday? August 12th. That's August 11th. It'll be a week tomorrow. 1 o'clock, be available, Mr. Armstrong.
It's been counted too, so I
Want to do it this morning, 11 a.m.?
I could, 11 would be fine, Your Honor.
All right, 11 a.m. on the 11th, status. And then if Mr. Bolter's in on the case, then let him know about that, Mr. Gillespie, so that he can be on that conference or ask for it to be changed to the date he'll be available. All right, thank you.
Thank you.
All right, Teresa Sharp is up next. She's in custody.
The next one, yes, Teresa Sharp
Okay.
and Clayton Yoakum.
What is your name, ma'am?
Sharp.
All right, Teresa Sharp. All right, case number, 22-0155, State of Ohio versus Teresa Ann Sharp. Ms. Sharp is appearing on video, a Zoom, I should say, with jail. Her attorney is Jacob Wagner, appearing by Zoom, and also appearing by Zoom is prosecuting attorney Collins. Defendant is charged with three co-defendants in Mulvey County, Idaho. Looks like she's charged in counts 5 through 16. This is a first pretrial. Final pretrial set for the 7th of September. Trial date is 26th of September. So the defense did request discovery, and see discovery has been filed by the state. Has defense filed the discovery yet?
I have not, sir.
Well, it's per the local rule to do a pretrial. Anticipating pretrial motion.
Not on my first review of the evidence, Your Honor.
All right, and written plea provided.
Yes, Your Honor.
All right,
I
and
apologize, sir.
defendant aware of that.
Yeah, I went out yesterday, with the discovery and the police form, or the, officer.
All right. Any other matters discussed at this time?
Your Honor, if I may, I've spoken to my client yesterday. We went out and spent a little time together. I know the bond, just being blunt, is not relatively high from what we normally see, but speaking with Ms. Sharp, she indicated she has various health issues, Your Honor, COPD. She normally has breathing treatments that she's not getting right now. She has diabetes. She's under the supervision of a doctor out at the lake. She's on a fixed income of SSI, Your Honor. She's $841 a month. We're just asking the court to consider an OR bond or even lowering the current bond. It's something she could make, Your Honor. I will say that speaking with her, I mean, she was very labored and breathing. I'm not a doctor. I don't know how great her health is, but it seems legitimate, Your Honor.
All right, Mr. Collins?
Mr. Wagner is correct in that the bond is not egregious based on the nature of the charges. Would also note that Ms. Sharp does have 2 prior felony convictions, one in 05 and one in 07 in King County. So I'm not sure what her ties to Hyden County really are, other than the trafficking cases that she has here. I'm not sure how long she's been here or anything of that nature. We just asked her to take those.
Where are you living, Ms. Sharp?
226 East Lily, Lot 10, Ohio.
And who lives there besides you?
Justine.
How long you lived there?
I've been there over a year. I've been in Hyden County.
All right. Court will reduce the defense bond to no promises only, as your promise will appear. If you fail to appear, you could be prosecuted for additional felony and convicted and sentenced by the Agricultural Act in this case. Also, making the likelihood of prison or conviction in this case much more likely. Your probation as soon as you are released, and then the previous conditions and the original entry still apply.
Thank you, sir.
All right, thank you.
Ms. Sharp, please call me when you get out.
Thank you.
Yes, ma'am.
All right, next one, Michael Barber. He's not in jail.
Clayton
Who else is there?
Yoakum out of jail.
Clayton Yoakum.
Catherine, Miss Habner's.
Yeah, Clayton Yoakum. Marcia, she has, OR only, and it had no way, so they're at back out of jail. And, put it in, she's reported the probation meeting. All right, are you Clayton Yoakum, currently there in the jail?
Yeah.
All right, this case number 22-0163, State of Ohio versus Clayton Yoakum, present for the, or he is appearing by Zoom, present, representing, Mr. Yoakum is Catherine Hackner, appearing by Zoom for her office, appearing on behalf of the state is prosecutor Attorney Collins, then in charge of police assault on, police assault, I should say. This is a first pretrial, final pretrial is August 17. Trial date is September 19. the state provided discovery, to the, and, I don't see yours yet, Ms. Packer, you not yours yet.
He has two cases pending. I know I filed it one, I may not have filed it the other.
Oh, okay. I don't have the other case on the docket today, what is that?
It's,
It's 104,
What is the case?
Olivia, small-time peace officer.
Yeah. All right, well, for some reason that must have been scheduled before, but I don't have it on today's docket, okay. So, all right, well, I don't see discovery in this case yet, so just checking, and we'll do every time pre-trial, as you anticipated pre-trial motion.
no, Your Honor.
All right. And has been a written plea offer provided?
There has, I have given that to my client. I have visited with him at the jail, we've given him this discovery in both cases and given him the plea offer in both cases. My concern is just how much of that he is comprehending and understanding.
Okay,
We had a competency evaluation in the other case.
Oh, that's right, I forgot about that, okay, all right. Well, yeah, I understood that, I recall it said you had to take a lot of time to so forth, but, you know, you need to work on that, Mr. Gilbert, listening carefully to your, attorney and, discussing those matters so that, you understand what's going on. All right.
I will have to make a motion to continue the trial date as September 19th is my regular day in Fayette County.
Okay. Go ahead and make that motion. I think, he's being held on the other case anyway.
Yes.
It has no date set that I can find.
On the other case?
Right, I don't think we set a trial date.
All right, well, then we better get that filed. There's a second case on Mr. Yoder. You could have it for me. All right. This, I have 163. Do you have the other case number there, Andy?
104.
104.
Let's use your 104. Late and go. All right, now the other charge is assault on a peace officer. Is that a deputy, a road deputy?
It is.
All right, and the one in this case is the CO. So they're separate instances, so at this point, it seems to probably have to be separate projects. So, did we do the competency, hearing on Mr. Yoder's case?
We did.
Can't believe it didn't get a trial, they said.
On July the 6th.
Wow, okay. And that was my first or second day back, so I was still good. Trying to get back into work mode. All right, so, I don't know what the time on that is. When was that one indicted?
It was indicted on May the 3rd.
Yeah.
The state filed a request for a competency eval on May the 12th.
Okay. And when do we have the, hearing?
July the 6th.
July the 6th?
Yes.
Okay. And he was, which day was indicted again?
May the 3rd.
Okay. When was he arrested, you know?
Probably April the 4th.
Yes, April the 4th.
Okay, so it'll be 29 days prior to competency, then 5, 12, 7, 6, and before that day, he asked for discovery or anything like that before the competency.
We did.
Okay.
We filed our response to the discovery on May the 3rd, so it must have asked for it right away.
All right, so
She asked
we're
for it on,
going to hold on that then. All right. I have that case now.
only one day of tolling. She asked for it May the 10th, and we provided it May 11th.
There is no entry in the file in that case. I think I understand why. I think I know what happened there. So.
That one right there, that's trash.
scheduling of disruption, so,
Right. 2 years.
the entry was not easy. And, we will set a final free trial for the city. I'll go back and figure the time then. So, the 9 days, so it would be 6 Mondays, 5 to 6, so that would be 25, 31, be 56. We have a September. That makes me good anyway. Did he help with other charges?
No,
Okay. And maybe we'll ask off. Okay, well, in any event, we, looks like we need to move up. For that one. Although I haven't, the other guy's not on yet, but, and it's discovered that, well, no, yeah, it is positive discovery. Did you file a policy on this hacker?
I did in the 104 case.
Okay. Yeah, I see it here. You filed yours on the 13th. All right, so actually that's an extra 10 days then. From 5/13 to, 5/3 is 5/13.
no, Judge. No,
Wait a minute, okay, resident April 4th, 5/3 request for discovery. No, better than that. It was rated on 5/3. And let's see. This is what the discovery request is.
May the 10th.
May 10? Alright. Alright, so that's on the last two extra days because of that, May 10. Okay, so. Alright, so May 4th, 5/10 is all count. That's, 36 days. And this holds up May the 10th to the, 6th. So that means there's 4 days, so, July 5, 8, 31 is Friday on it. So, that's why, we have set for a profit, that's it. Alright. So, the 19th is on the other case. Alright, so, set a trial for August 22nd.
That's my regular day at county.
And it's Howard Hertzler.
Oh, that's right. Other than that, I will not be available, we'll have to get a visiting judge for August 29th. That will be the weekday. Hopefully, that's already signed. Alright. You have any open this afternoon?
I do, yes.
If it's worked out, I'll take a plea, but if there's gonna be a trial, then we'll have the visiting judge be here for the trial on that case. You're gonna need to, get a visiting judge for, August 29th on that case. But that's back practicing an entry that I've found the conflict in entry, of 5 and 6. And, I have entry that they 29 and see if that judge will trial if. Yeah, it's 12 a.m. doesn't do it. Now, with regard to, oh, wait a minute, Marcia, I gave you the wrong file. That's the 104 case. Okay. Yeah, back in the corner. Yeah, okay, that is right. Okay, you got it right. Yeah, but here, yeah, I made those here. August 29 and 30, this is good. All right. And on this case, then, we'll set this one for trial. This evening.
It's set for trial.
Yeah, but that's the day she's gonna not be available. She said. So we'll go ahead and do a continuance on that now. Yes. The case is that various continues to request the defendant. We have a, we'll keep the August 17th. Let's make the final pre-trial September 2nd instead. And then we'll set the trial. In that case, September 26th, if that's your regular day. That was 19th is your regular day.
Right, yeah, nice, sorry, do that.
September 26th. Yeah. All right. Any other matters you need to discuss then in this case?
No, Your Honor.
All right, thank you. All right. Let's see.
No more videos, Your Honor.
No, I took care of him this morning. He got a diet again. And I appointed Mr. Wagner to represent him. He finally decided he didn't want to return. His attitude was basically improved today.
Cases, but it's a couple days a week, things that.
Yeah, he finds out how to He hasn't been. I think that's it. Then we're good to jail.
Wait, Your Honor, we have Mr. Barger at 1 o'clock. He is not shown. He's Mr. Armentrout's.
You mean on Zoom?
Not a Zoom, but he's an hour late.
Okay.
I don't know if Armentrout's heard anything from him.
All right. We'll do case number 22-0154, State of Ohio versus Michael Barger. Hearing on behalf of the state court of this assistant prosecutor King, Mr. Armentrout, present by Zoom from the earlier pre-trial by Zoom. Mr. Barger has not appeared. Do you have any knowledge of about Mr. Armentrout at 1 o'clock in person? It's now 1:55. So, if you can locate, if you can get a message to him to call in or come in today, we can go ahead and do it and get him in here before.
You said it has to be a good reason?
Well, yeah, I'll accept that reason. Yeah. Yeah.
He's not contacting me, or I don't know if I may have a phone number on the financial